Landlords, it has happened again. The Assembly and the Senate of the state of New York has passed legislation that was signed into law by Governor Kathy Hochul on January 1st, 2023. I'm your host, Matthew Lyman of the Landlord Advocates. Welcome. This oppressive new law is called the Tenant, Dignity, and Safe Housing Act. It is a law of a number of pages that we're not going to read page by page and go in depth with you. We are going to share with you the nuance of this law and how it affects you as a landlord, housing provider, and yes, property manager. What this law basically does is it allows tenants to take their landlord to court in a special summary proceeding based upon the conditions of the apartment in which they are living, the habitability, the warranty of habitability of where they live. They take you to court. They file the paperwork. What the court will then do is decide whether to dismiss the case, or they will require you to fix the property, of course. They can give a monetary award to the tenant, $1,000, $5,000, $10,000 to the tenant, for the conditions that they're living in, or they can reduce future rents until the problem has been remedied. The law allows, and I quote, the law allows the court to have any relief the court deems just applied to the landlord and against the landlord and in favor of the tenant. Any relief. It also goes on for them to say the court will also have broad discretion to fashion relief. What does that mean? Broad discretion, broad relief opens up the door to a lot of nastiness towards landlords. Now, when the special petition proceeding is filed in the court must then send a copy to the building inspector, the code enforcement officer, or whatever that agency is called in your municipality, will receive a copy of that notice. Now, we all know that tenants in the state of New York, now this law applies mainly for landlords outside of New York City, that they have the option of going to the code enforcement office to issue a complaint about the condition of the apartment. Then the code enforcement office will come and inspect, issue a citations if necessary to the landlord, issuing the landlord to come to court to face the charges by which were applied to them by code. If the court deems that they are valid, the court will then tell the landlord to fix the property and issue fines. So the tenant already has liability. When they do that, if the landlord starts an eviction process against the tenant, it will be seen as retaliatory eviction. What this law allows the tenant to do is to circumvent code enforcement, circumvent the building inspector, and go directly to the court and have the court hear the case without having code involved. Now, when the court involved code afterward, hopefully that they will. But when this happens, if the landlord files an eviction against the tenant, it will be seen as retaliatory eviction. So your tenant can be falling behind in rent, have problems in the apartment, file a special summary proceeding against you. You take the tenant to court for non-payment of rent. The tenant can claim, well, we're not paying the rent because of these conditions of the apartment. Oh my God, they're so bad. Oh my God, what do I do? And you can be cited for a retaliatory eviction. The court has determined who are the respondents in this special proceeding. That is, who are the parties that can be sued? There are four. One, obviously, is the deeded owner of the property. One is a government entity. The housing authorities, any entity, a government entity that owns rental property, and this was New York City, meaning the New York City Housing Authority, which we know that they have a lot of problems over there. They have over $450 million in uncollected rents during COVID, but yet they're mandated under federal law that was passed in 2019 to put the properties up to standards or face fines. But yet they have $450 million of lost rent that they cannot do that with. So it's a government entity, the deeded owner. The other one would be anyone that is on a residential registration list, like in particular in the city of Schenectady, if the landlord does not live within a certain proximity to the city, they must name an agent, namely a property manager, who would be on this registration, who would be notified if there's any issues with the property. The other one that affects property managers is this, and I will read it specifically. Anyone who holds themselves out as a landlord by such actions as collecting rent, making repairs, signing leases, or other such conduct. Well, we know that's what property managers do. So now not only is the owner of the property being brought into this, but so is the property manager, who can be on the hook for thousands of dollars for damages that the tenant is claiming that they've had to live with. Now the court will impose those damages upon property managers and or landlords, the actual deeded owner of the property. So basically the process would be the same in court, but instead of you being the petitioner and the tenant being the respondent, it's the other way around. You as the landlord are now the respondent and the petitioner is the tenant, and the respondent is you, the landlord. Now, here is the icing on the cake regarding this law. It is so disgusting, it is so wrong, that we hope it will be challenged in court and dismissed in its entirety. This law will be dismissed in its entirety. Are you ready for this, landlords? This is terrible. Under this law, the court clerks are mandated, and they must help the tenants fill out these documents. Now, the documents have not been promulgated yet. They will be by the Office of Court Administration. This law does not go into effect until another 180 days. But in that time frame, those forms will be created, and we will examine those and share them with you when that time comes. But here is a case where the tenants can go and complain, and the court clerks are now going to be filling out these forms for the tenants to sue you, the landlord, you, the property manager. Now you're on the hook. Here they are. The court is actually going to be ordered by the state of New York to help tenants fill out forms to sue you, the landlord. Now, it gets even worse. Are you ready for this? The service of these documents must be done in the same manner that a landlord would have documents served upon their tenants for eviction court, housing court. But, oh, wait a minute. That's not necessarily the case. There's another option that is provided to the tenants that is not provided to landlords in landlord-tenant summary proceeding eviction cases. And it goes like this. Personal service may be completed by the court clerk or on any natural person, partnership, corporation, or limited liability company by mailing the notice of petition and petition by certified and first-class mail to an address where local property tax bills are sent. What this means is that the tenant can go to the courts without a pen in hand, just verbiage coming out of their mouth, complaining about where they live, your apartments are falling out, even though you probably have a certificate of occupancy or a rental certificate. They can do that and complain. The court will then have to fill out the paperwork. Okay, tenant, hold on. I gotta write this all down, hold on. They write this all down, and then the tenant says, okay, you're gonna take care of that for me, right? You're gonna see to it that my landlord gets that. Oh, great, thanks, bye. Take it easy, have a great day. Then the court then has to mail it out, certified in first-class mail, to the landlord. Now, nothing in here says the landlord, or the tenant rather, has to pay this fee, the same fee that landlords have to pay when they file an eviction proceeding in towns, villages, and city courts. So that's not saying any of that. So now here we are, again, as we said earlier, an oppressive law placed against landlords, housing providers, and property managers, where a tenant can screw up the property, destroy the property, break this or that, then go to the court, circumventing code enforcement, complaining about the condition of the apartment, had the court clerks fill out the paperwork for them, only had the tenant sign the document saying, yeah, this is true, which, how do we know that it's actually true? And then the court then shows the landlord, and the landlord or the property manager has to come to court to defend themselves against actions that may have been taken by the tenant in retaliation of the landlord saying, hey, listen, I want you to move out. You're not paying the rent, or you're destroying the property. I want you to move. This is wrong. New York State keeps passing legislation into law against housing providers, landlords, whatever you want to call us, and it has to stop. It has to stop. Landlords, you know that we're here with you, we're here for you. We ask that you subscribe to our channel. You hit the notification bell to be made aware of future videos. You hit the like button. And of course, you share this video across not only New York City, but across the nation. Because what happens in New York can happen in Kansas, Louisiana, California, Washington State, and can happen anywhere. We must keep ourselves informed. Therefore, we can be advocating for ourselves, our desires, our needs, our wants, to protect our property rights. Until then, landlords, take care.